That matter where the child was to be examined at Newlands, the concerned officer went to the society with police. Police was not allowed to enter. They said they're not giving the child up. And the council, unfortunately, to the other side, has said, try to take the child, we will file a complaint against you. Non-compliance of this honorable court's order will be required that this matter be taken up for some further direction. They've not done anything so far. They've not filed an appeal. There's no order passed. In the absence of any other order, this order has to be
Urgent.
What is urgency?
Wherefore, respondent, my lord, mother is not allow the child to visit his father, my lord. 22 matter.
22 matter, now the mother is not allowing the father. And
From 22, my lord.
Just it on one day. Yes.
granted for visiting on 22nd, my lord. Right, because the train should come from Spain on 21st, my lord. It was ordered in the chambers, my lord. Difficulty is, my lord, due to the plane crash, my lord, the variation of the visa requirement, the child would come on 24th, my lord. Hence, my lord, I seek a small modification to have that on tomorrow.
Yes, tomorrow.
Memo for being
Only one memo a day.
memo for being spoken, my lord. Small correction with
Yes,
regard
yes.
to case.
Tomorrow. Yes.
Memo for posting and for wicket sale, lordship.
Yes, tomorrow.
Memo for posting, ma'am. Memo for posting.
What is urgency?
Transfer guidelines are released. Transfer guidelines are released, ma'am.
What is that?
Transfer guidelines are released.
Transfer?
Guidelines. Transfer guidelines, ma'am. Teachers. For teachers.
No, this court is not having that roster.
WP.
No.
FCS.
Please call the list. Adjournments page wise.
Adjournments page wise, list number 1.
Serial number 14.
Hmm?
Serial number 14.
No, she call page wise.
Page number 3, serial number 4. Page number 4, serial number 5 to 10. Page number 5, serial number 11 to 20.
14.
Oh.
Serial number 14. Tomorrow. Senior is
Coming up for preliminary hearing.
senior is
Huh?
senior is not pending. Tomorrow.
Number 19, my lord.
Oh.
Tomorrow.
Inform the other side also, say number 19. Yeah, the next week, any day.
At the request of land counsel, the petitioner is this matter next week. It is submitted that it is already informed to the other side. Yes.
Serial number 11, my lords. I need 4 to 5 weeks time, my lords. My senior has met with an accident. So she wants around 4 to 5 weeks to recover, my lords.
Inform the other
Yes,
side.
my lords. I have informed.
Not I will. You have to wait till 11.
I have informed already.
Huh?
I have informed already.
You have already informed. It is submitted that the counsel for the petitioner has met with an accident. List this matter after 4 weeks, and it is submitted that it is already informed to the land counsel for the respondent. Yes.
Number 4, my lord. Serial number 4.
4.
4 also you will mention. Can't you wait? Yes.
Page 6, serial number 21 and 22. List number 3, matters referring to Lok Adalat.
Serial number 16. List number 3, serial number
I think these are all going.
Serial number 16. Serial number 16, where I pay for the petition. The order has to go, ma'am. There is no settlement in this. Where as on the date of passing of the order, she is a gainful employee, she is an employee.
RPSC 16. It is submitted that there is no scope for settlement, delete from this list and post the matter in the usual course. Yes?
Any day, tomorrow or day after tomorrow for the admission.
No, it is listed for that purpose. It will come in the usual course. Yes?
Still number 25, my lord.
Uh,
Appointment. We need
No, all the matters will be referred.
much.
Number 11, my lord. The matter is already settled before the trial court. Maintenance amount is also paid.
Then file a memo, will pass order.
Type, not typed.
What is that?
It's not typed, it is an handwritten now.
Handwritten memo.
That's fine.
Serial number 11.
Okay. It is submitted that already the disputes between the parties are amicably settled. And nothing survives for,
Permanent alimony is paid.
permanent alimony is also paid. As such, nothing requires to be adjudicated in this petition. Accordingly, dismissed, recording the same, memo is taken on file and the petition is dismissed as withdrawn. Yes. Remaining matters refer to Lok Adalat. Call the list. Which one? No. If it is settles, then it will come back.
List 1, serial number 1. Srinivasa KN.
This matter, it was called for the connected matter, wherein this court has held that the vehicle involved is Tata Chariot.
Two cases and in one case already an order in favor of the insurance company.
Two appeals were filed. And here this house court has said that the vehicle involved in Tata Sumo, not the present case. So on that judgment I have produced, and it is also.
No
tagged along
representation
with
on
the-
respondent side.
So in view of that judgment, my appeal has to be allowed. It's already pending. And our way, this insured vehicle is not at all involved.
We'll give a final opportunity tomorrow. Yesterday, there was no representation. Today also, there is no representation on behalf of the respondent. List this matter tomorrow and finally orders will be passed.
Serial number 2, Aishwarya R.
Tomorrow,
Tomorrow, it will come in the same caption.
2:30.
No, it will come morning. Yes.
Yeah, well, petitioners.
I told Akshita to keep all that, whatever that has transferred. Yes, it was agreed that it will be disposed of.
In the video, I still, my record, submission may be taken on record. There is no consent on our part. The submission was always that we would want the trial court records to be reconsidered. What transpired is that my lord said that if there is some reluctance on the part of the child because of whatever has transpired, let the child be present for counseling. To that we agree, saying that yes, the child be sent for counseling. Nothing further. That remains my submission. Counseling, there no.
Please come. Yes.
Already agreed that, my lord. They are
That's what I'm going to do now. Yes.
council instance, my lord,
Oh.
demands are my.
Yes. Please come. Agreed with orders passed on I number 2 in JNWC number 257 of 2021, dated 8th December 2021. The father is before this court. Father as well as the mother are before this court. The father's petition is WP 1912 of 2022 and the mother's petition is WP 20817 of 2022 and another petition is by the father is WP 4987 of 2024. The family court has passed an order whereby the father was entitled for interim custody of the child on any 2 weekends in a month and preferably during the first Sunday and third Sunday of the month with prior intimation to the respondent. He shall pick up the child on Friday evening at 7 p.m. and shall drop the child 5 p.m. on Sunday without disturbing the studies of the child. And also, the father is entitled to celebrate the birthday of the child, and the mother shall hand over the child to the interim custody of the father on every birthday of the child from 10 a.m. to 3 p.m. And he shall pick up and drop the child to the mother's house. And also, he shall hand over also the mother shall hand over the child to the interim custody of the father for 8 days during the winter vacation and for 15 days during the summer vacation. And it is also observed that the father is entitled for communication right to speak with the child through video call for 1 hour on every second and fourth Sunday between 10 a.m. to 11 a.m. or 5 p.m. to 6 p.m. This order is dated 18th December 2021. Take the other case. Order sheet. This is not the one. Next matter. In WP 4987 of 2024, a series of orders are passed by this court. The matter has come up before this court on 27/3/2024. From 27/3/2024, several orders are passed by this court, and this court has made the whole endeavor to see that the father gets the visitation and they'll be able to spend the time with the child. Wherein on 27/3/2024, an order was passed whereby the father, mother, and the boy they should go to the Phoenix Mall, Bangalore, on Sunday 31/3/2024, and father can exercise the visitation rights from 11 a.m. to 3 p.m. The court had interacted with the boy. In the chambers, along mother, father, and also along with the boy. And as the boy was reluctant to go alone with the father, this court has observed that the mother shall also be accompanying the boy. There again, the court had interacted with the three of them on 2/4/2024. On that day, it is submitted that everything went on well on the last meeting, and the boy expressed that he is little confused whether to talk or not to talk, and also afraid that father may take him away. Then the court observed that under these circumstances, things have to be taken slowly, as it is concerning the welfare of the minor. Then the court had passed an order permitting the father to exercise a visitation on 25/5/2024, 26/5/2024, and 1/6/2024 from 11 a.m. to 3 p.m. at Kapan Park. On 3/7/2024, when the court had again had interaction with the boy in the chambers, he stated that he had good time because of the places, but not because of the father. And father has stated that he was always been with his mother, and he never had a good time to spend with the child, as a mother was also accompanying during the visitation. If an opportunity is given to him to spend time along with the child, it will help him to develop the bonding with the child. And during the course of interaction, the child got an impression as if this court is going to send him with the father. He started crying and saying that he wants to be with his mother. Then the court has also observed that it's a responsibility of the mother to see that the child interacts with the father and the boy develops a good vibe with his father, as she has the full control over the child. And accordingly directed that on Friday, that is 5/7/2024 at 6 p.m., the court has passed an order that the visitation on Saturday, 6/7/2024 between 11 a.m. to 2 p.m. and on next Saturday, that is on 30/7/2024 between 11 a.m. to 2 p.m. at Anjaneya Swami temple, which is opposite to the house of the mother. And the court also observed that the mother shall make all efforts to see that the bonding develops between the father and the son, and what are the efforts made by her shall be submitted before the court on the next date of hearing. On 16/7, it is brought to the notice of the court that the boy felt that it is boring as he has to sit at one place. Then the court had convinced both the parties and convinced the mother that the father will take the child to a resort which is situated in and around Bangalore. It is acceptable to both the parties. And court has observed that the child shall leave on Saturday. Three of them shall leave on Saturday on 27/2024 at 10 a.m. and they can come back by Sunday, that is on 21/7/2024. And on 24/7, it is submitted before the court by both the parties that visitation in the resort went on very well. And the court in the order passed on 24/7/2024 has observed that when the both parties can settle the disputes pending amicably, and also they can come up with a joint parenting plan. And both the parties have submitted before the court that they require some reasonable time to think about it and come to the court on how they want to go ahead on the joint parenting plan, and also settling the other disputes. And as both of them have submitted that even for exercising the visitation, no order is required and they can be amicably be decided, then the court had observed that in the meantime, at the convenience of both the parties, the father can exercise his visitation rights. Even in the order dated 18/9/2024, it is stated that both the mother and the boy, father had spent good time. And when it comes to the settlement, both the parties have their own versions. According to the father, he's earning an amount of rupees 29 lakhs per annum, and the mother submits that on the day when she left the husband's house, that is 4 years back, his salary was rupees 24 lakhs, and her salary was rupees 28 lakhs per annum. Considering the fact that the parties want to settle the matter, and only the dispute is with regard to what is the income, this court has asked the parties to file the assessor liabilities before the court, as per the law laid down by the apex court in Rajneesh versus Neha. And mother has been taking care of the educational expenses of the child. Whatever the educational expenses that are spent shall be placed before the court, so that the court will pass further orders in that regard. And court has also observed that he shall fix the appointment with the passport office, and on that day both the parties shall appear before the passport authorities and shall proceed with the further process. And by the next date of hearing, it should be informed to the court the date of appointment fixed at the passport office. All the expenses shall be borne by the father. And it is the apprehension of the father that the mother may leave the country after the passport is renewed. As such, once the passport is renewed, it shall be deposited before this court, pending disposal of this case. With regard to the visitation, on every Sunday, the mother shall drop the boy in the Cubbon Park at 10 a.m. and pick up the boy at 4 p.m. And in the meantime, if the boy is not comfortable, the father shall intimate the same to the mother. This arrangement shall go on till the next date of hearing. And the court, when it is brought to the notice of the court that the court in GNWC is insisting for day-to-day hearing, this court has passed an order as as there is a likelihood of settlement, there shall be stay of all further proceedings in GNWC number 257 or 2021 till the next date of hearing. And both the husband and wife undertakes not to proceed with any of the pending matters between them till the next date of hearing. Thereafter, there is a change. On 21/10/2024, it is brought to the notice of the court that the father shall inform the mother by tomorrow about the details of the appointment for the renewal. And considering the boy's birthday, the visitation was fixed by the court. And again, the court had reiterated in this order that they have to file the statement of assets and liabilities as per the judgment of the apex court in Rashesh versus Neha. Thereafter, the matter came up on 8/1/2025. It is brought to the notice of the court that the father has not deposited the passport before this court after the renewal. And counsel and a senior counsel appearing for the father submits that the order of the court will be complied with and directed the matters to be listed on 4/2/2025. And by the time the passport shall be deposited before this court, or else appropriate orders will be passed. Then on that day, it was brought to the notice of the court that the order passed by this court dated 22/10/2024, whereby the court had directed them to file their statement of assets and liabilities, was questioned before the Honorable Apex Court. And they said that the same was dismissed by the said SLP is dismissed. The court had directed the matters to be listed on 5/3/2025. And by the time the party shall place the respective statement of assets and liabilities, and the passport is also surrendered before this court. And the court had directed that it shall be kept in the custody of the registrar judicial to keep it in the safe custody. Finally, both the parties have filed their respective statements of assets and liabilities. In this matter, another important factor in this case is that the boy is suffering with a heart ailment. For that, he had undergone a surgery. And during that time, as it was not brought to the notice of it is the case of the father that without his knowledge, the surgery was done, and he was not informed about the details. Then he has filed a case against the hospital as well as the doctors. That writ petition was heard by this court, and the same was dismissed. This court, right from the beginning, and as per the orders narrated, as per the orders that are extracted in the preceding paragraphs had taken all the efforts to see that the child will spend some good time with the father. The father wants the visitation rights of the son. And when it comes to, it is a case of the mother that the father has not paying anything. For that, the answer is that no such application is filed by the mother. And according to the land council appearing for the mother in the domestic violence, what is that case?
Criminal is 75, 2022.
Criminal miscellaneous 775
2022.
2022. So far notices are not paid.
Because this is not.
Though they are aware of the pending matters, so far they have not appeared and they are evading the notice. And admittedly, no IA is filed in the GNWC. It has been argued before this court that the seeking statement of assets and liabilities, or it's not the scope of the writ petition. And as this court is conscious of the powers of the court and the jurisdiction of the court, while deciding a writ petition that is pertaining to the welfare of the child, this court has done all this exercise to see that an amicable settlement arrives at between the parties, and the boy who is suffering with the health ailments at this age need not be put to this kind of hardship. And this is a hardship. The boy has shown, except on of 2-3 occasions, all the time he has shown his reluctance to meet the father. For that reason, court was repeatedly trying to convince the mother and the child. And also, when both of them are saying that there is no scope for settlement between the parties as far as matrimonial issues are concerned, if a settlement is arrived at and a joint parenting plan is filed, they would be able to lead the life which is in the interest of the child. With all the best efforts made by the court, it appears that there is no scope for such settlement. From the interaction this court had with the boy, and looking at the order passed by the family court, in the considered opinion of this court, the order needs to be modified. Accordingly, this court is passing the following order. Number 1, the father can exercise the visitation once in a week, Saturday or Sunday, with prior notice to the mother between 10 o'clock to 4 o'clock. 4 o'clock, where the mother is also permitted to accompany the father. Number 2, the boy, with regard to the overnight custody or any other order, considering the state of mind of the boy at this point of time, this court feels that it is not possible. As such, every week, once in every week, the boy shall go for the counseling sessions in Nimhans, accompanied by both the mother and the father.
May I interrupt?
Yes.
Only one request. Whatever is being done is fine. One request came. NIMHANS is a more formidable institution. Mediation Center and the Deputy Director have advised the advocate on record. Child counseling is done under more conducive atmosphere at the Mediation Center itself, and the counselor whose name was mentioned in the memo has been fairly all right, although not medically or professionally qualified. I asked, is there any professional qualification? No. It is just that the atmosphere is more conducive. Would my lord want to consider that, or if NIMHANS only my lord?
Why you do not want?
Let them try it there. If it fails NIMHANS,
No.
NIMHANS
Why
is
do?
more formidable.
Why do?
Because of this is in mediation center,
Try
there
not.
is no medical facility. Say BP also various lot. It's a heart ailment is the concern of the boy. The medical facility is also there. There are the experts is there. That's why, my lord, I have no other issue. Because of
No, but where your client stays?
like in Bangalore.
I know that. Now, where is the mediation center? Where is NIMHANS? Which is easy for her to go?
Yes, my lord, it's nearly 6 kilometers.
Which is 6 kilometers NIMHANS?
Nimans to mediation.
It is not NIMHANS to mediation center. It should be from your house to NIMHANS, your house to mediation center.
Nearly.
Which is nearer to the
Nimans.
NIMHANS is near to it.
Nimans is
It is in NIMHANS so and so, accompanied by both father and mother. Once the counseling session is completed, the NIMHANS shall place the report before the trial court. Next one. Basing on the said report, the family court shall pass, the GNWC court shall pass further orders with regard to the overnight custody, visitation of the boy. Next point. The GNWC is of the year 2021, and so far the mother has not filed an IA for interim maintenance as they have filed in the other miscellaneous. However, if any application is moved by the mother, as already the assets and liabilities are filed before this court, the registry is directed to transfer the same to the trial court, and the trial court shall decide the IA within a period of on the outer limit of 1 month. Accordingly, all the writ petitions are disposed of.
Visa is already lapsed. Visa is he's an American citizen. Visa already lapsed. That has to be renewed, or otherwise it's passport is renewed. But the visa is not yet renewed.
In the interest of the boy, if the
Well, one second. We have no details about this. Directions are being passed, but
No,
I am
I'm-
a handicap.
no lower court, let it be all over.
Let him file an appropriate application with
It is
necessary-
submitted that the boy is a visa, the US citizen, and the visa needs to be renewed. In that regard, the petitioner, the mother is at liberty to move an appropriate application before the family court. And this application shall also be considered expeditiously, giving opportunity to both the parties.
And
Just
from a
two,
medical
well, he has a laundry list of demands. I have just two requests. One, once a week now, my lord is saying, that too accompanied by the mother. Request is at least that one day in a week, initially, let the boy spend time with the father alone. If there is any reluctance, the father will report that and then the mother can join. But let him at least have some time directly with the boy alone. Then if there is any reluctance or
Because,
something, if there is reluctance, there's no point.
No. In all those orders I've seen, that boy is not coming. That's what that's the endeavor made by the court. He'll be unsuccessful, I know, because I've seen it.
Because there is some DV case we are not even aware of. Then the mother will accompany the child. The child will be only with the mother. The child, because there is some element of
That's why
situation that has happened.
simultaneously this weekly thing will be happening and simultaneously counseling will be happening. Once the counseling is done, let the report be placed before the court. The court will pass appropriate orders, the trial court.
Vacation also, at least the family court had allowed. That also has now been taken away. Vacation time, at least if the child is allowed to spend time with you.
Oh, that is not possible the way the relationship is going on between them. Yes.
Expenses, my lord, they have to pay, my lord, medical expenses. They should not interfere with anything happen in a medical issue. They should not interfere, my lord. Or otherwise, he will go to school and
As of now, the custody of the child is with the mother with regard to the child's school and the all other aspects till any further orders are passed by the court. Mother would have the complete control on all the affairs.
counseling expenses also. Counseling expenses, yes.
The counseling expenses shall be borne by both the parties equally.
Number 3.
My lords, I appear for the petitioner in this matter. Seeking a day's accommodation, my lords, we have retrieved a copy of the NIMHANS report only last evening. We require a day's accommodation, my lords. Matter may be taken up tomorrow, my lords.
Where is the other
My lord,
side?
for the respondent, my lord, we have no objection for the same, my lord.
Tomorrow.
Please, my lord.
Yes, next.
Number 4.
My lord, I am for the petitioner, my lord, matter. Mediation is not settlement.
Huh?
Mediation not settled.
medicine.
Yes.
Only 2 weeks time granted.
Why? Why
Senior
2
is
weeks?
not feeling well.
Who?
Senior.
My lordship, there are arrears of more than 8
Let's
lakhs.
see.
I am
In the order sheet.
They are not paid any maintenance in spite of the order. There is arrears of maintenance more than 8 lakhs. At least conditional order may be passed because this is a old man, 79 years old man.
Doesn't standing amount of
Because
together.
by virtue of this interim order, we can have, there is a execution proceedings has been not moving.
Standing account in respondent. Balance.
There is an order.
No,
of
there is no
10%.
conditional order.
There is no conditional order.
How can it be? How can there be a blanket order? We'll modify that order. And what is the amount that is granted?
More than 10,000 per month.
No, you can take your time. I'll modify that interim order earlier granted. You shall pay 5,000 per month and the arrears at 5,000 within 8 weeks from today.
Yes, ma'am.
Yes.
Get instructions.
I clarify, ma'am.
This matter will be called after the next matter. Talk to your senior. Tell that the interim order would be on payment of 5,000 continuous by 5th of every succeeding month and arrears also at 5,000 from the date of petition till now within 8 weeks.
Yes.
Serial number 5. The baby MP.
Here for the petitioner, first matter. Matter
Yes.
pertains to the order of the family court, my lord, awarding maintenance. Petition filed by the husbands challenging the order awarded, my lord. In fact,
How much is granted?
but 80,000 was granted, my lord. And
Where is the impugned order?
the order is at page 20, annexure A. To pay 80,000 for the wife, date of the
MC is filed by whom?
order.
Both parties have
I-
filed MC.
She's seeking for enhancement, we are seeking for reduction.
No. MC
Both
is
parties have filed, my
Both have
lords.
filed, my lord.
This order is passed in the husband's MC because we had filed the application in husband's MC and order is passed in husband's MC.
So she filed a petition for divorce in US. They are making all wild allegations. In fact, she went to the embassy also making allegations that I and my daughter who studying there would have lost her status over there. I was compelled to come to this honorable court and file the case in India. Then she came here and she filed this case. There, at that time, we disclosed that she has filed a case in America. In America,
So where the parties are now?
he is in America, she is in Bangalore. She's staying in the matrimonial home, which is jointly owned, and she's taken heart of the city near the family court, my lord. That's Wilson Garden near the Lal Bagh. That's where she's staying, and she's alone who's staying here. He was working. He lost his job in November 2022.
Yes.
Thereafter, my lord, I was compelled to come here. I could not immediately travel because of COVID and other restrictions. So I came here and then I filed this writ petition court. I also filed my accessory liabilities on. My lord,
Yes.
now the question is, my lord, in the given circumstances, what should be the maintenance that should be given to the wife? In this
What is she doing here?
She is not employed.
Okay.
And there are 2 children who are 30 plus and 28 plus. They are major and one daughter, my lord, the 38 and 26. That is the age of the daughter. 31 and 26. That's the age of the daughters. After she completed her education here, she wanted to study abroad. That is the elder daughter. So I financed her travel, her stay, living expenses, and her education, taking loan. Partly I cleared, but now after she's employed, she is working, she's clearing the loan. Now the younger daughter is studying her MBA medicine that she's doing there. Now, my lord, that's taken on loan. I am now paying for living expenses and taking care of her expenses, which goes for nearly 3,000 to 4,000 a month for her only. Now, considering this aspect, I don't have any income now.
$3,000 to $4,000
for the living expenses for the child. I have stated in my assets and liabilities what are my expenses that I.
What is the age of the parties?
58, my lord. More than 58.
Hmm.
Now, my lord, the petition is under section 24. It is not a section 26 application where permanent alimony is to be looked into. They are now looking into what assets I have, what means I have, etc. Now, what are my means? I have placed on record, my lord, that I have lost my job. Annexure L, K, and L are the documents which are there saying which is what is my when I was retrenched from
When
my
is
job.
this order passed?
Regulars, madam?
This order is passed when?
4th of August 2022, my lords.
4th August 2022.
Please, madam.
When you lost your job?
November 2022.
You're not doing anything even from 22 to 25.
I don't have avenues, my lord. I reached a particular stage in the computer section, my lord. It's difficult to get a job. I'm not getting any job. I'm trying to do various. What can I do? How to earn the money to generate income for myself. I'm now leasing out the car I own for rental. I'm getting the money from that. Now I've sold the car also. I don't have the money. One of the house which my daughter was staying, the rooms I've renting that. I'm getting the money from that. That's all is my needs as of now. I started to do whether I can do real estate. I had to study for that exam and go into real estate. I could not succeed on that. I've stopped that. As of now, I've taken a franchisee, which is now commenced recently. I have to make a lot of investment, which I have done. There is no returns so far now. There's no ROI insofar as that business is concerned. That is the franchisee of like how we have a postal like courier service. That's what I'm doing right now. That is the only means that I have now. So, and the rest, my lord, considering that, my lord, in my accessory liabilities, I placed on record what are my expenses. Because I have to pay the EMI for the house which I'm staying. And that's partly owned by me. I have to pay the mortgage for that. I have to pay the property taxes for that and take care of the children. An older daughter, my lord, in America, traveling and commuting is not very easy. Public transport are not easily available. She wanted to buy a car. I partly paid the money for her car. Partly she's taken by loan. That also has to be financed. All these expenses are there on me that I will not be able to pay. 40,000 is what the court has ordered, my lord. Considering her application, if you lordship may kindly say her application, what is it that she asked for 2 lakh rupees? The house she's staying is no rent is being paid for that. Her expenses, according to her own application, my lord, she wanted for some the means that were the
where is that
headings on which she's claiming maintenance, my lord. Page 118, my lord. 120. Her monthly expenses, what she has now claimed as the date of the application. Apartment maintenance 5,000, household, phone, internet, electricity, food, inclusive eating out. All this comes to 44,500 rupees, my lord. The first 5 items, 1, 2, 3, 4, 5, which are necessities. Next, transportation inclusive driver's salary and petrol, car, annual insurance, maintenance. The car has been sold admittedly by her, which she claimed I do not have. I've sold the car. So this expenses so far as 60,000 does not arise because she has sold the car now. Travel including vacation, but I don't have any vacation at all because I was working throughout without taking any vacations, and so that I can make my both end meet and also support the 3 of them who are in India and their education and their future, children's future. Emergency savings, provident fund, insurance contribution. All these are something which is looking at future savings. But she has enough savings which I have given her in gold as well as FD which is with her. When I was paying monthly maintenance for her, my lord, when I was working here, enough money was there. I used to spend when both the children were, when I went to 2015 to America, I was sending 3 children, both of them and the child were here, the wife and 2 children. I was sending 1.5 lakh rupees plus credit card expenses, whatever was made claim I was paying. Once the children grew up, and the elder daughter, actually younger one, expressed her desire to study in America. So therefore, my lord, I took up a transfer. Staying in India, I could not afford to send a child to study undergraduation in America, medicals. So I took up a transfer to working the same company in US, moved there in 2015. She also came to America. She's living with me. Now she's working. She's studying in University of California and Los Angeles. That's where she's studying. She's completed her undergrad and now she's doing her medicals. Now, in this circumstances, my lord, what would be the quantum of maintenance to be paid for a person who's staying alone? She has a home to stay for her living expenses here and home to stay in the house which she does not have to pay any rental for that purpose. 40,000 is what I could afford and I am paying that amount, my lord. On application also it said I can pay 40,000. I was paying, my lord, 50,000 now, 80,000 till this honorable court interim order was granted honorable court, my lord. That was a strain on me to pay 80,000 rupees. Now I don't have all my assets which I had, my lord. I have sold it. With that income, I am now trying to do a business. I have not generated any returns on that so far. That is my affidavit which I filed for the contention they have raised that I have other savings, other means of generating income. So therefore, my lord, 40,000 I'm ready to pay and I'm paying that amount, notwithstanding the fact that I don't have any expenses.
Yes.
But the court has drawn adverse inference against me that I have not filed assets and liabilities. I could not come to Bangalore for various reasons. My lord, one, there was COVID. Second, there was the leaving the job and coming, my job would have been in stake. I had to file this application or furnish all the details to for me also to place it on record, my lord. I have now in this before this honorable court, my lord, I have placed my assets and liabilities. Where I have stated.
Have you filed your objections to that?
My lords, I have filed my detailed objections and I shall argue on the false statements that they have made. In fact, today we were planning to file.
No, I just want to clarify that. Yes.
Not in this, I'm stating what are my income.
Where is that dated?
Assets and liabilities, my lord, I filed on 19th August 2023. In this petition 18607, in 21376.
Next.
In her petition.
In that. Yes.
But page number 17 is my expenses sheet that I have, income expenses, my lord, and all the documents. He does not have good health. Now losing his job at this stage, and he's humiliated to even say that he has to rent out a portion of the house to get the income from the home for to his meeting his own expenses, my lord. In the affidavit, my lord, I have stated that income tax returns have been paid and that the loans are there for my older daughter and younger daughter.
Is it at page number 22? Income and expenditure.
Please, my lord.
Yes.
Page 17, my lord. This is one house is there, which is leased out in Bangalore, my lord, that's 27,000 rupees. Repair, maintenance, and that is other expenses. So far as in India, what is the income that he generates? In US, my lord, he gets a salary that he has lost a job. Rental from one room and the car rental was so much. This was $3,300 that he was earning. Then the home loan, the car loans have gone, my lord, because he could not pay the loans. The cars have gone. He's got one car now. Health insurance for himself and his daughters, car insurance, home insurance, property tax, utilities, auto expenses, travel, home maintenance, health, daughter's maintenance, and even the wife's maintenance, my lord. That's $1,000. At that point of time when I filed this, I was paying 80,000. $1,000 is what I am saying is what I was paying. In all, my expenses comes close to $20,000 per month.
No, they are fighting the litigation in US also. Both of you are fighting the litigation in US also.
As of now, my lord, the ruling is given that you have to exhaust your remedy here. So therefore, that is now we have raised objections regarding the jurisdiction of American court to grant because she has never lived there, never there. Both parties have never lived there or stayed there, and the marriage took place here and the last lived together here. All the cause of action took place in India. Therefore, the court has given a ruling that we have to exhaust our remedy here. That also is produced by us.
So according to you, still you require.
There's a shortfall with which I have to now raise funds. How am I going to raise funds? What am I going to do? What am I doing? With all this, my lord, I'm still supporting both my children. Though I lost my job in 2022. 19, the older daughter came as she finished her course. Now, at least living expenses I have to pay for her. She may be taking a loan, she must be clearing the loan now. The arrangement was that I will clear the loan, all other expenses till she completes her education. Thereafter, she will do it. Now, the younger daughter, I have to support still. The older daughter, my lord, whatever expenses as a child, whatever I have to do, I am ready to do. Now, here also, my lord, I am not denying her that I will not pay. That because I don't have a job, I am not going to pay for you. Whatever I can do, I am doing this. She is staying in a 3-bedroom house in the heart of the city, which if rented can be drawing more than ₹1,00,000 per rent. So my respectful submission, my lord, is that this is not an application under section 26 where we are looking into alimony and then status, etc. Various assets and income generated, we look into it. But what is the current income I am generating? Under section 24, it is support for the wife during the pendency of the matter. This matter, my lord, I could not go on with the divorce case. Divorce case would have concluded by now. In her petition, my lord, there is an interim stay of further proceedings. I just could not do anything. When I came to India, then I got to know that there was a in 2022, there is a stay of further proceedings. I moved this on to court many a times just to at least vacate the interim order. We can have a progression in this matter. We can reach a finality. My lord, she is also sought for divorce. I also sought for divorce. That matter is
There
pending
shouldn't be
here.
a stay of MC proceedings. Why should there be a stay in MC?
Ought to have been in that manner, my lord, but this honorable court had said stay of further proceedings. Not only the interim order, but stay of further proceedings.
Yes, what do you say?
My lords, to tell in 2 minutes what the facts of the case is. There was one girlfriend that he was in relationship during his college days called Deepika Chopra. That did not happen and she got married to somebody else and he got married to the petitioner wife here. They lived happily. In 1992, they got married. They had 2 kids. They lived happily. Thereafter, in 2013, he gets in touch with this woman whom he was dating earlier before marriage and who is also undergoing divorce. Thereafter, they both start meeting, start going around the world and starts living in the US. He says he wants to go to work to the US. He goes to the work for the sake of work in 2015. From 2017, they start living together in the US. The house that they are living right now is also jointly owned by the paramour Deepika Chopra and the husband here. My lords, why this writ petition needs to be dismissed is, if your lords may kindly take my writ petition, my lords, may I request your lords to
What is the number of your writ petition?
21376 of 2022, my lords. If your lords may kindly have page 100 is the application filed by me for maintenance, which is 2 lakhs per month and for litigation expenses. If your lords have page 110, is there objections which they have filed? My lords, I filed my application on 15/7/2019. They filed their objections on 21/8/2019. My lords, thereafter, in Rajneesh versus Neha's judgment came in November 2020 and 2021, I filed my assets and liabilities. They have been contesting the matter all through. Counsel is appearing all through until August 2022. That is, my lords, almost 2 years after the judgment, even after there was direction from the Honorable Court to give the assets and liabilities, they refused to give. Their statement is that he was in the US, he could not come to give the assets and liabilities. Nowhere it says that he has to be physically present. The fastest FedEx will come in less than 4 days to India for just $100 rupees. If he sends in the normal India Post also, it will come in 16 days and it will reach India. They chose not to file the assets and liabilities because they did not want to disclose the actual assets and liabilities. That is reflected in the order passed by the learned family court also. In fact, my lords, that statement is at page 57, categorically telling in the operative in the order, my lords, page 57, 31 paragraph of the order. In page 57, my lords.
Yes.
Para 30. The petitioner has tried to file his assets and liabilities to show that the respondent is capable of earning of her livelihood or the amount of rupees 50,000 which he has been paying by him since so and so is sufficient for her maintenance. It was a choice that they made to make sure that they do not disclose assets and liabilities. But now, after about a year, they filed this writ petition challenging and they have filed their assets and liabilities. If your lords may kindly have their assets and liabilities, which they have filed, my lords, even in my petition they have filed, my lords. Kindly, your lords may have page 3, my lords. Starting from the assets and liabilities, there's a separate document as a whole, my lords. If your lords see page 2.
Yes.
My lords, in that column 7, he says general monthly expenses is about 19,475. About $19,000, which is almost equivalent to 18 lakh rupees. He says that's his expenses, which includes maintenance paid for wife and daughter and EMI for the house loan, car loan and education loan and insurance and property tax. Here is a case where he took the daughters from India, telling that he will keep along with them and give the best education. After which he kicked the daughters out because his paramount's daughters are also living in that house. She has 2 daughters and they were living in the same house and there were constantly conflicts because of all these illicit relationships and the daughter had to step out. Both the daughters are completely taking care of their expenses. The first daughter, who's about 30 years old, finished her education here and went for her master's. She took the loan. He was just a guarantor. She is paying all through the loan. Whereas in this document, which they have filed assets and liabilities, they have faked it saying that they have paid the document. So lords, if your lords may kindly have, I have that in their assets and liabilities, my lords. At page 58, they say that is a document that they have produced.
Yes.
Saying that they have paid that EMI loan. If your lords may have that document, that is not a statement of receipt that they have paid the EMI. That is just an account statement as to what the EMI is. And he is just a co-signer. If your lords may have at page 59, it is written what he is. Because they were dependents and went on his visa, he is just a co-signer and she is the borrower. That is at page 59, my lords. I have produced a document before your lords, which I produced on 10 February 2025, showing where the daughter has produced the document telling she is the one who's paying the EMIs. Exactly of this month he is trying to claim. This is a statement which is pulled out of 20th of August 2023. I have produced the document to show at page 10 of my document, my lords.
So according to you, what is according to them, what's the amount?
The EMI, my lords, every month. My lords, every month the EMI which goes is $1,429, my lords.
$29.
Yes, my lords.
That's
42
equivalent
cents.
to?
My lords?
Equivalent to?
Up to when the loan is?
Rupees.
In dollars, they're paying in dollars only,
my lords. Because the loan
They're
is
in
from the
America.
US.
Both the daughters are in America.
The loan is from the US.
No, that
bank.
I understand.
Yeah. It is $1,429, which she is only paying. I have produced at page 13 her entire bank statement, showing that including this, what August he claimed that he has paid the EMI. That is his statement in his affidavit.
Apart from that?
Apart from that, my lords, if your lords may kindly have, he's produced one document. My lords, I am not sure if they filed. They have served me a copy of the rejoinder. See, I don't know if they have served, if they have filed it in the counter or produced before the court. On 10/4, they have served me a copy.
Yes, what it said.
That document again further lies. My lords, I request your lords to kindly take the documents that I have filed on 10/2/2025, my lords. I have produced the proof of the house, which is worth almost 25 crores, which he's living, along with the paramour. And he is the joint owner and he admits. My lords, after that, I have produced one document in respect of the companies that is running. What's the reason for his dismissal from the company? There was a layoff. He is not an ordinary employee. Lords, his monthly salary, not even annual, his monthly salary was 50 lakhs in Indian rupees. It was about $53,000 per month is what his salary was. He was a director. He was not an ordinary person to be laid off. The reason why he was laid off is there was a conflict where he was doing the same business in terms of IT consultation along with his paramour and had set up a company. And the company got to know that he's doing exactly the same thing because they are also into IT services. That is when he was being laid off. I have produced the documents of the businesses that he is running. If your lords may kindly have that document, it starts at page 21, my lords. He's been running these businesses with his paramour, earning crores of rupees on a monthly basis. He's now filed a rejoinder according to his whims and fancies, does not disclose what these businesses are, just says that this business is done by so and so. Just now they produced one rejoinder. If you also kindly look into that rejoinder at page 2, my lords.
Page number?
Rejoinder that they filed today, my lords, at page 2.
Yes.
At para 4, he says that the fees is about 1,10,000 USD per year. The petitioner has arranged for a loan which will be sanctioned every year and has to be repaid after she completes the course. The petitioner has to support all the contingency expenses for the younger daughter. A lot the younger daughter absolutely is taken loan on her own. I have the documents before me where all the loans are taken by her, including her daily expenses of food also, my lords.
Have you filed your bank statement in support of all these transactions? Your bank statement.
They have not, Miller.
No. When you're saying that these particular amounts I'm paying towards my daughter's education, towards my EMI and all, does your bank statement reflect all these entries? I think under these circumstances, we'll ask your client to file an affidavit before the court, or is the whole purpose, as per the judgment of Judge Rajneesh and Neha, any misrepresentation or suppression of fact amounts to perjury,
Absolutely.
and perjury proceedings needs to be initiated.
The bank statements are there, my lord. I will verify whether.
No, not that. No, I'll pass a clear order. What it is. That is one aspect. Second is, will not, why the proceedings of the family court be stayed?
My lords, that has been said. I have no problem if it's.
Let it go on. Let it go on. Let it go on. Let him come up with an affidavit before this court.
Absolutely no problem.
So that let we'll vacate the stay in your case, and in her case, then we'll ask him. I'll record all your contentions.
Sure.
And with regard to that, let him come up with an affidavit.
And I want to make one submission. How decisive and how much of lies that they are putting on record have been. This order was passed in August 2022. This writ petition was filed in 2023. He has sold a property which was in his name, but purchased from the funds from the joint property which was sold without her knowledge on 15th of December 2022 for an amount, this is as per records, for an amount of 4 crore 20 lakhs. Hasn't disclosed anything about this in the assets and liabilities, even though the same is filed after few months. That's the conduct of the petitioner husband herein. All that he wants to do is to harass his wife and his own children. And he's happily living with his paramour and spending money for the paramour children. And their father is fighting for their rights in the US. And the divorce proceedings of that paramour is also happening in the US. That's the conduct herein, my lord. My lords, my request is, there is an interim order for half of the amount to be paid. My lords, 40,000 is absolutely not sufficient for me. And my learned friend again made a statement that there is no car and there is no expenses at all. As of today also, she's come to my office in the same Volkswagen car, which is almost 12 years old, and there are so many numerous issues in the car. And there is maintenance that is required. Their interim order has been granted for only half of it, which is 80,000, which was the order passed. I have filed for enhancement from 80 to the 2 lakhs that I have sought for. they have sought for reduction, and this honorable court had reduced the amount to 40% in the interim order. At least that 80,000 be paid till he files the SHNF, till he files the latest affidavit, because she is having huge difficulty. And they think expenses mean only today's food and everything. Well, not last year alone, that building that she is living in an apartment complex, they have painted. You have to pay and contribute for the paints of the apartment. She pays 1 lakh every year as a maintenance, my lords. And her food, expenses, and she's never worked. And she's lived a comfortable life. And suddenly, because he wants to show his interest back to his ex-girlfriend and starts living with her in the same house, and they produce that document as well. Let them pay 80,000 till the order.
Both the wife and husband are before this court questioning an order granted by the family court dated 4th August 2022, whereby the court had granted interim maintenance of an amount of rupees 80,000 against the claimed amount of rupees 2 lakhs. Against the claimed amount of rupees 2 lakhs. Learned counsel appearing for the husband submits that husband is not in a position to maintain himself. He is out of his job from November 2022. He has to support his 2 daughters and has to take care of himself. And the amounts that are claimed by the wife are exorbitant. And she's not she's not in need of 2 lakh as claimed by her. It is submitted that by renting the other rooms in the house, by renting the car, which is the car, he's deriving some amounts from that, and also with that he's taking care of himself and also the daughters. As such, it is a submission that the husband is not in a position to pay the amount. Next paragraph. Learned counsel appearing for the respondent wife submits that the statement of assets and liabilities that are filed and filed before the court and the petition, the rejoinder that is filed before this court is with all suppression and misrepresentation of facts. It is the case of the husband that he is taking care of the daughter's expenditures when they themselves are paying, and in that regard, she has filed a document to show, and an affidavit also, and an affidavit filed by the daughter.
Not an affidavit. She's just given the document and produced
document
that as one of the
to show that she is paying the money. It is submitted that the husband is living with his paramour in the house jointly owned by them, and as he was indulged in doing a similar business,
That is not based on pleadings, my lord.
that's what she's saying. I'll record
Not in
it.
the pleading. It can't be based
That
on the
is
court
my
record.
submission, my lords.
And where did they get it? What did they do? That
No,
cannot
that's
be
her
made.
submission. I'll record the
Cannot be a
submission.
part of the order, my lord. Then I will not even be getting a job over there. So not even based it in the pleading, my lord. In case
It is submitted that he is doing some other business as of now, and in that regard, she has placed the documents before this court to show that he is doing business, and he's doing business and sufficiently earning. For that, a reply is filed. Without mentioning, without giving a clear reply to the same. It is submitted that the property, which is jointly owned by both the wife and husband, was sold away. Has been he has
owned by him, my lord.
It was
owned by him. Owned by him. He sold that property on 15th December 2022, and he for an amount of rupees 4 crores 20 lakhs, and the statement of assets and liabilities are filed on when?
That was filed on
August 2022.
August 2023, my lords.
August 2023, the statement of assets and liabilities are filed. But in the said statement of assets and liabilities, there is no mention about this particular sale transaction, which is a relevant aspect. And counsel submits that all these aspects clearly disclose that there is suppression as a misrepresentation of facts. Further, it is submitted that as per the judgment of the apex court in Rajneesh versus Neha, if such statements are made before the court, the necessary proceedings has to be initiated against the party who has misrepresented the facts before the court. It is also submitted that this court, in the writ petition filed by the husband, had directed to pay an amount of rupees 40,000, and it's difficult for her to lead her life with that amount. Next one. This court has heard the learned counsels appearing on either side and also produced the material that is placed before the court. Prima facie, the documents that are filed by the husband and by the wife, and a bare perusal of that shows that there is some suppression on the part of the husband in bringing all the facts to the notice of the court. And it is an admitted fact that the transaction with regard to an amount of rupees 4 crore 20 lakhs is not reflected in the statement of assets and liabilities filed before this court. And with all.
We have stated the properties are sold, my lord. We have stated the property.
Then what happened to that money?
That is what he is now doing the business. He's taken it to America and is doing business out of that.
They have not stated that.
Huh?
They have not stated that. My lords, there are multiple properties in Delhi which he is transferring it to the paramour's name. I am trying to get that document. I will get that as well.
You have denied that, my lord, that no other property other than what is
the husband shall file an affidavit before this court that all the statement of assets and liabilities and all other statements that are made before this court are the correct statements, and nothing has been, no property or any other transactions are not suppressed by him, and the companies which the respondent wife is referring to as the businesses owned by him, whether it belongs to him or not. A categorical statement in the form of an affidavit shall be filed before this court, and basing on that, the further orders will be passed. Next, number 1. Number 2, this court in so and so has granted stay of all further proceedings, that is wife's petition number so and so.
21376.
So when impugned order is with regard to an interim maintenance, in the considered opinion of this court, staying all further proceedings is not necessary. Accordingly, the stay granted by the court in WP number wife's petition is is vacated. Next, coming to the order, interim order that is passed in the petition filed by the husband, this court has granted an amount of rupees or stay on the condition of depositing an amount of rupees 40,000 per month. The same is modified, and the husband shall.
An order on this, my lord.
I have also
Yes,
filed.
record. I won't even have the means. Let me produce the document, then your lordship may modify whatever order, my lord.
My lords, I have filed vacating. It may
Monday.
kindly be.
Because how can you file it? Because he is
That's
staying
the
in
reason,
yours.
ma'am.
In
Let's-
2 weeks.
So we'll say, we'll select him pay 60,000. He was there already paying 60,000.
40,000, my lord, please, let it be, I conclude it, I'll get the documents and place it, then your lordship may hear and pass now. Once.
When can you get it?
You have to send it, my lord, and after.
That's why it will take some time.
But within that time, I will.
In
place it on
these
record.
circumstances, court cannot believe the story of your client. He has not stated all the facts. No, if he is
Also find out.
if he is
what
fair.
My lord, I'll find out what is it that he can ready to increase, my lord. I'll make that submission, my lord. My lord, all this is 1 month more, my lord, in next few weeks, I will place it on record. Your lordship may finally dispose of it.
Then stay vacated, that also you don't know.
Very well.
Then list this matter on
Next Friday or something. I can't get it.
1
from
week,
there.
it can't, it is not possible. List this matter on 1st of July,
Much obliged. 2nd July.
2nd,
3rd July.
3rd July.
Obliged.
Call that.
Serial number 4.
Where is he?
Serial number 4. Vijay Kumar TM.
Tomorrow? I'll come tomorrow.
Serial number 6. Jayaprakash Reddy M.
Yes. Where is the respondent?
Yesterday there was a session, my lord, and the data has asked us to come on 23rd. Will be taken up on 27th.
It's submitted that
In the
the
meanwhile, my
matter
lord,
is going to come up before the mediator on 24th,
23rd.
23rd. This is matter on 27th.
But in the meanwhile, my lord, since from January, my lord, the respondent husband has not paid the maintenance, my lord.
I'll verify and check. I'm not aware.
There will direction to pay it before, on or before.
I'll verify, my lords, let me know, because as I'm told, I'll get back to
If he
this.
has paid, my lord, I will not claim. If he has not paid, let him pay it by, since from January, my lord, 6 months, not even a single naya paisa is paid.
Yes, 27th is coming.
Please, my lords.
Before that, let him pay the.
No, how can there be a direction in a review petition? Please understand the court's difficulty. Also, can there be a direction in a review petition? Asking them to pay interim
Oral
maintenance?
directions, my lord. It's oral
What is the
because, my lord,
sanctity
there
of
will
a
be-
oral direction? No, I'll tell them to do 100 things.
I demanding him. is separate.
Pay the maintenance.
Please, my lord.
Yes. Next.
Please, my lord.
7. Serial number 7.
For petitioner in this case, my lords. My lords, the notice has been served to the respondents on 13th. The same has been reported to the registry on 16th of this
What
Monday.
notice to respondent? Where did the court ask you?
My lords, service, regarding service of.
Where is the order?
Notice on online.
Service report.
Who is the caveator?
My lords, I am the petitioner.
No. WP, you gave a wrong file.
1794.
On the counsel appearing for the respondents before the trial court. That's the order. You have to serve on the counsel, not on the party. To whom you have served?
My lords, I have served on the party, my lords.
No. As per the order dated 2/6/2025,
My lords, I will
the
get it
petitioner shall serve the copy on the counsel and shall file a memo to that effect.
My lords, on 25th, the hearing date in the trial court, my lords, kindly have it on Monday, my lords, if so possible.
So what? If it is on that day, you will serve the copy.
No, my lords, before that itself, I will file the copy, my lords. I will serve the copy.
No, any of the court will not grant stay of all proceedings before the court, even if the court interferes with this order. It will only, it's an interim maintenance or you're seeking maintenance.
The respondent is seeking maintenance.
You're for the husband.
I'm for the husband.
That's what, even if the court interferes with this order, then also the proceedings will not be stayed. The notice. He has taken it on the party. The petitioner shall take out hand summons to the council and shall file a memo to that effect. Once it is, memo is filed, list the matter. Yes.
Serial number 8. Ravindra P.
And to the respondent.
Yes.
Maintenance order passed by.
Please use the mic.
maintenance order was passed by the family court,
Oh.
considering the fact that salary as well as the financial statement of the petitioner. Now there is a change of circumstance. He was terminated from his work due to the fact that he has to appear before the court every now and then. He was not able to work in those duration. So considering that fact, it may be, the order may be reconsidered in this aspect.
What is the material before the court to show that there are changed circumstances and you are not earning?
My lords, I have placed on record in the family court that there is a termination on 30th November
30th November?
2024.
What is his occupation?
My lords, he was a tour manager, Annexure tour manager
In?
in one of the company. It's a
Private company.
Annexure B. It's been placed, my lords.
It's a private company.
It's a private company.
What is his salary?
So he was getting around somewhere around 30 to 35,000.
Court has granted?
35,000 for the daughter. Due to his financial
So
statement,
you said what was your salary, I'm asking?
35,000 per month.
That court
Why
has
this
granted?
35,000 was made by the family court is, he had several transactions in his financial statement over 2 lakhs, 3 lakhs, something as such. These were the some amount which been given it to me by some other persons for these tour management and as well as these things. He has also borrowed some of the money. By seeing that financial statement, the court has come to the conclusion.
So now it appears that your job, your salary has no nexus with the maintenance that is granted. If the court has only considered your salary,
Yes.
then 35,000 is salary. So why would the court grant 35,000 to the?
This order was passed in 15th October 2024. I was terminated.
Where is your present bank account?
My lords, I have placed the ITR returns before this court of 2024 and 25.
Bank statement.
Bank statement I have placed, assets and
No,
liabilities.
no. After the order, according to you, it's after the order.
After the order. After the order, I was terminated, my lords.
Correct.
My
From that day till today, what is your bank statement? Is it before the court?
No, I haven't placed.
Place it.
Place it. I'll place it, my lords.
Is there any interim order?
No interim order.
There is
But
none.
I'm filing my objections to the document.
Today
May I
the
have a
account-
2 minute, it will be disposed today. If I can be permitted to speak for 5 minutes, I will get the matter itself disposed.
My lords, I'll
I
place
will
the
show.
financial statement and then it may be considered.
It is
because
there.
I
I'm
placed-
submitting all the documents.
Yes.
My lord, in the writ petition filed by the petitioner, the husband, my lord, this honorable court has heard the same matter some time back, my lord. Kindly see the petition submitted in the petition documents 18 in annexure G, my lord. The petition documents in their petition, my lord. Main petition documents, annexure G. At page 89, my lord. This honorable court dismissed the writ petition filed by the husband because, my lord, at that point of time, the issue was a little different. It was about divorce done ex parte, suppressing the address of the wife and getting an ex parte order behind the back. A miscellaneous petition was filed, and, my lord, thereafter, the learned family court, my lord, had set aside the decree of divorce and restored the case back to file. At that point of time, this honorable court has noted in its order in page 96. In page 96, my lord, in the last, in fact, from the husband's side, there appears to be clear suppression of facts before the court below. This honorable court has noted, after going through extensive documents in that writ petition, I won't trouble this court with all those documents, my lord, but the point here is the husband is used to suppressing facts. The husband is used to misleading courts. Husband is used to filing false documents and giving false information.
This is completely.
And let's start with the first thing, my lord. The petition address itself, my lord. Kindly see. Petition
No,
ad-
I've already read this order, so
Read,
we
my
will
lord.
not go into all
Will
that.
No, not
Now we will be.
This is
we'll
only
be look-
reconsideration of the.
so far as the income of the person, my lord, what they have said, the changed circumstances, my lord, may have appeared after the person has resigned. But my lord, even what we are saying is that is not a job, that is a hobby for him. The true income of the petitioner is not from the tour manager. Even from their own document, it shows that he is a freelancer. My lord, he has admitted in cross-examination that he likes to travel. He likes to travel and go along with people and take them along so that he can make friends and therefore business. He has admitted in the cross-examination, my lord, in my document, that it is not a full-time job. Kindly see, my lord, the documents that I have submitted.
taking his.
It is not a full-time job. And my lord, the bank statements that he has submitted along with the affidavit of assets and
For a
liabilities.
statement after 15 December 20, no, what is the date? 13th November, 13th November.
2024, he was terminated.
That is exactly where I am coming from, my lord. The petitioner does not give true facts. Even in his AL, he has lied throughout. We had to extract the information from the bank statements that were given by him under compulsion by the Learned Family Court. He was not even willing to give the bank statements. The Learned Family Court forced him to bring the bank statements, and when the bank
What is
statements,
his income per month as per
my
that?
lord, his income, kindly see page number in the documents that I have given, my lord, in page number 113. He has not given one single document about his earnings, my lord. Only what we can do is extract information from the bank statement because he's used to suppressing, my lord. Kindly see page number 113. This is his HDFC bank statement for the year 2024, my lord. That from 2023-24, this is the bank statement consisting of almost 98 pages. Kindly see the last page, just to give an idea, my lord. They say that his salary is between 25,000 to 30,000 a month, my lord, which means he should get not more than 3 lakhs in his bank statement completely as income. But kindly see, he gets 69 lakhs 58,000 rupees as credits in his bank. Where did he get that money from? Now the escape route is, they are loans. Provide any documents that they are loans. No information given. Well, Lord, he is earning substantial amount of money because he has admitted tour is only a temporary, it's a part-time job. He likes to travel, he does that. He has admitted in his cross, my lord, in page number 280, my lord. Kindly see page 280 of my petition. In 280, he says in his cross-examination, 280, my lord. Lordship is there, my lord?
1 minute.
My lord, in para 29, he writes, he admits, my lord, tour manager is not a full-time job. Other than tour manager, I do a lot of social services. I am the chairman of National Human Rights Committee and I am the state president of National Republic Party of India. In addition to this, my lord, he is also having 9 companies. He says some of them are not functioning, but he has not given all the bank statements to the court. He has suppressed information there also. Forget all that, my lord. I have reason why I wanted to bring this address part of it to the knowledge of this honorable court. In the writ petition that he files, he writes, my lord, his address is in RT Nagar. This address, my lord, the reason why I am saying this, my lord, suppression, it is a systemic thing with him. In everything he suppresses. Before this honorable court, in the writ petition filed, he gives fake address. The same address we have gone ahead and cross-examined him, my lord, wherein he says that this is, he has come out of it in 2009, my lord. Kindly see that. Page number 267. Page number 267. In this, my lord, in para 11, in the year 2009, I shifted from 62A of RT Nagar to 2305 Sahakar Nagar address. If he has shifted in 2009, my lord, why is he using that address in the writ petition today? It is because it is his habit to suppress facts. He has given a false address of the wife, even, my lord, when it in the petition, kindly see, he has given again repeated the fake address of the wife for which he was censured.
My lords, here, what has happened
This is
here,
continuous.
may I submit, my lords? He doesn't own any property in Bangalore.
He owns in
is
Kerala.
one second. He is staying in a rented up place. One of the sister stays in RT Nagar. Here, what happens here is he has to travel back to Kerala. He's native. So whenever he doesn't pay rent, the owner will vacate the property and they will throw out the belongings of the petitioner. Since there are some persons over there, they can collect. I have placed. I don't have any self-acquired property or ancestral property in Bangalore. What I have done is I saved some part. I have provided some part to my wife at the time of marriage. She sold that property. She went to Goa. In 2005, she went. She never came back from 2005. 2012,
You're going in a different direction.
That is
Yes.
already settled matter.
What you have to submit is, either you have stated something on oath in a evidence
Yes,
before
madam.
the court,
Yes,
or you are stating something wrong before this court. Which one is correct?
my lords, here,
Not.
these are the rent.
We don't require an explanation on that.
Please.
Here, your address is resident of 62/K
Yes, madam.
6C cross, second main road.
Kindly
Yes,
see
ma'am.
verifying
In
affidavit
the
also.
year 2009, I shifted from 60 so and so, RT Nagar, so and so. Then why are you showing this address again?
My lords, here, what happened here was there was a change of counsel. There was a change of counsel after this also. And what happened here was he had to get a relief from this court. So he came before me. And these addresses were not notified by him. He has read the petition. He has read the petition. And he doesn't own any property in Bangalore. He has to get a rental apartment. One of the person, RT Nagar, his sister lives there. He will reside both in this place as well as that place. And he has to, when he...
What did you say before the family court that
My
I
lords,
vacated
both,
on that?
I've accepted the fact that, my sister lives in that RT Nagar.
Except, let us read further.
My lords,
There is no such admission, my lord. In fact, my lord, a
It was
sister also
Sahakar
admitted.
Nagar, due to mistake, it was typed as Shankar Nagar. From 2013 to 2015, I stayed in the aforesaid number 1831 of Shankar Nagar address. Then
The
I think we
entire
should,
addresses are fake.
my lords, here,
difficult, like when the court is asking him, unless and until I ask you, you shouldn't
Oh,
respond.
Right.
my lords,
I think we need to, some, perjury proceedings needs to be
my lords,
initiated.
here, there is no purposeful suppression of any facts because he has coming to the...
You cannot say furnishing some address in the writ petition and say that it is not, purposely it is done. How can you say that? Can you give an address where you are not residing to the court?
My lords, here, he is not having any place in the Bangalore. He is staying with us.
Some address.
My lords, here he is staying in sister's place. Even this present address also, the agreement was with the another sister. He used to stay with her. This is how he is managing. He does not get any income.
Your client is not understanding. That is very much clear. At least you should understand what is the query of the court and where in which direction the court is thinking.
Well, I'll get instruction. Why he has made this statement, I'll get the instructions from
Please
him.
come. No.
Well, here maybe.
No.
Well, here it is not the genuine case that wife has.
These kind of people cannot be, these kind of litigants cannot be entertained at all.
My lords, one submission. It may be taken up. Annexure.
First of all, I am not interested to go into the merits of the matter. I will be dismissing this petition
My
on the
lords,
ground
here,
that
one
you have come
submission.
before this court with there is with unclean hands.
My lords, one submission.
And in the light of the earlier order passed by this court, the conduct of the petitioner is very much evident, and the petitioner is still indulging in the same manner.
My lords, may I submit, my lords? Kindly see the order of this IA number 5, Annexure A, page 15.
Yes.
When the matter was in a state of objections of the respondent, the main petition as a last chance, and finally, the respondent has filed the application seeking for interim maintenance of 1.25 lakhs with annual enhancement of so and so 2.5 lakhs, supported by the affidavit so and so. Once there is a clear direction from this honorable court, the matter should be concluded within this framework of 6 months. They file the application of these kinds to drag the matter, although they know the matter that I don't work.
You pay the maintenance, court will take care of it.
My lords, there must be some consideration after 30th November 2024 because what here, my lords, here I'm not able to get back either the sold property which she has got. She has sold the property in the Bangalore. She has taken 2 apartments in Goa.
Surprised that the client is taking it so lightly that he comes before the High Court and furnishes an address where he is not residing,
Well,
which has been where you have deposed before the court on oath.
Yes, my lords, he has made a mistake on that regard.
Please
He has,
come.
my lords,
I
here
think
he
all is
doesn't
past
own
with-
any of the rented apartment in
Right.
Bangalore.
In
That
MC
may be
number
recorded, my lords.
833 of 2010, dated 15th October 2024, whereby the court had granted maintenance of an amount of rupees 35,000 to the daughter from 11/7/2024 till disposal of the petition, and litigation expenses are of rupees 50,000 to the wife. Where is that 5,000?
5,000.
5,000 to the wife and 35,000 to the daughter, and one-time litigation expenses of an amount of rupees 50,000. It's a case of the land counsel appearing for the husband submits that the husband has lost job on 13th November 2024. He was working as a tour manager and earning an amount of rupees 30,000. As he lost his job, he is not in a position to pay the maintenance, and all these aspects were not considered by the court. Learned counsel appearing for the respondent wife submits that the petitioner is in the habit of suppressing the fact and suppressing and misrepresenting the facts before the court. He has placed before this court the bank statements that are filed, wherein the income for the year 2024, the statement shows that it is 69,58,000, and if the submission has to be taken on its face value, he should not be more than his income should not be more than 3.5 lakhs.
My lords, here
3.5 lakhs. Credits
these are
should not-
financial transactions.
That is his
Yes, that's
submission. 3.5 lakhs. It is submitted that in the earlier round, when he has obtained an ex parte decree of divorce, when they have filed an IA miscellaneous to set aside that order, court had allowed it, and the same is questioned before this court. This court, while dismissing the petition filed by the husband, has given a finding that there is suppression on the part of the husband with regard to the address of the wife, and when he is constantly in touch with her, still that fact was not brought to the notice of the court or to the wife, and he has taken notice by way of substituted service, and on that basis he had obtained an ex parte decree.
There was a publication also, my lords.
That's what I said, sir.
Paper publication.
And he has obtained an ex parte decree, and this court has observed that there is no illegality with the order passed by the family court and dismissed the writ petition. Land counsel submits that before the family court, he has deposed that in the year 2009, he has shifted from 62/A of Artinagar to 2305 of Sahakar Nagar address. And he doesn't remember the month of the shift. On the date of the filing judgment in the case on 1/10/2012, he was staying in 2305 of Sahakar Nagar. Land counsel points out that in the present writ petition, he again shows his address as 62/A of RT Nagar, which clearly demonstrates that how the petitioner is coming up before the courts with all suppression and misrepresentation of facts. It is submitted that in the evidence, it is stated that he is a freelancer and doing the work of a tourist manager is his hobby. It is submitted that he is having several businesses and is earning income out of that. And this petition has to be dismissed. Next one. Having heard the counsel for the counsel on either side peruse the material non-record. A party who comes before the court seeking a relief should come to the court with clean hands. When he has deposed before the court, what is the date of deposition? On 15/1/2025. On 15/1/2025, that he has vacated the premises, that is 62/A of RT Nagar in 2009. He gives the very same address in this writ petition. The land counsel has, for the petitioner, submits something which has any nexus and which has no connection with for giving this kind of address, furnishing an address before this court. When he has stated on oath before the trial court, that needs to be taken into consideration. And in that case, what address he has furnished before the court is a wrong address. And what are the reasons for furnishing such an address before the court? And playing with the process of the court is not known to this court. Considering the bank statements that are filed, the previous conduct of the petitioner, and also the address and other suppression of facts before the misrepresentation of facts before this court, the petitioner, the litigant, like the petitioner, is not entitled for any kind of relief from this court. In that view of the matter, this court do not find any reasons to interfere with the order passed by the family court and accordingly dismissed. Will dismiss it with cause.
Well, that's here. There is no suppression. Only thing is he is giving the address of the sister. Nothing apart from that. There is no suppression.
Yes.
In fact, there was a final decision.
No, I just asked you about the cost. How much?
Well, that's, I don't think so is able to pay that.
Yes, next.
Serial number 9.
Well, that's if at all, if there is a direction for consideration after 30th November, the family court might consider that.
Not necessary.
Serial number
Yes,
9.
Please, ma'am.
Yes. No representation. Let's just matter after 4 weeks.
10. Sumangala S. Swami.
This
Yes.
sister and the respondent husband and wife, they got married on.
What is the impugned order?
Impugned order, my lord, the court has allowed 5,000 for the wife and 3,500.
5,000 to the wife?
Wife and 3,500 to each child. There are 2 children.
3,500 to each. That is 7 plus 5.
This
12,000.
case, the contention is that, my lord.
You're for the husband.
Yes, my lord.
What is your income?
He is now not having any income because he suffered a stroke.
When?
In annexure A, I have produced, my lord.
Date.
And also he in 22 he suffered a stroke.
In the year 22.
2022.
What is his age?
Date, my lord, 5/5/2022, and he was
Oh, what is his age?
age.
Age of the petitioner.
Age, my lord, his age is now 39 years.
39 years. What is he doing?
Now
What
he is
was he
not-
doing?
Now he is not doing anything because the doctors advised because of the stroke he cannot work, and he is assisting his brother in construction work. That's all, nothing else. In fact, in spite of the order of this family court, my lord, he is paying all the fees of the children and all the expenses, but only he is unable to pay the 5,000 for the wife. She is also very well educated. She can, and she herself deserted him and went away from the matrimonial home, my lord. She, from the day one.
So your submission is you will pay 7,000, but you will not pay 5,000.
No, I am not saying I'm not, at present I cannot pay because.
No, that's what at present is your submission.
Yes.
That you will pay 7,000.
Yes, my lord. We pay.
With 7,000, their education will be complete.
No, my lord, his brother is paying all the education expenses and school fees.
So I'll record that you are ready to pay. You are paying all the educational expenses and also
That has been produced before the.
7,000 towards the maintenance of the children.
Yes, my lord.
But due to your financial condition, you are not in a position to pay 5,000 to the wife.
5,000, actually, the 7,000 also not able to pay, but his brother is helping because of the
Please
children's
come.
education.
Land Council appearing for the petitioner submits that family court has awarded 5,000 to the wife and 3,500 each to both the children. It is submitted. It is contention of the Land Council for the petitioner that the husband had suffered a stroke because of the doctor's advice. He is not in a fit position to work. With the support of his brother, he is ready to take care of the all the educational expenses of the children, and also 7,000 to be paid to the children, to the son or daughter,
Daughters, both are daughters.
to the daughters. And as far as paying maintenance of 5,000 to the wife is concerned, it is difficult for him. Next, considering the submission, there shall be stay of all further proceedings on the condition that the petitioner shall continue to pay 7,000 by 5th of every succeeding month and shall take care of all the educational expenses. And in respect to the 7,000, if there are any arrears, they shall be cleared within 4 weeks. Yes. Stay granted. Notice to the respondents.
Serial number 11 adjourned. 12 Shivarama DA. 11 is adjourned. 11 is.
Which case?
11 is adjourned in the morning.
11 is adjourned already. What was it recorded? Morning they said that they've informed. They are not informed. Not informed.
Today we have filed the wakalat.
Well, their name is there, no? Dhanush Menon. I've recorded in the order also saying that they said that they have informed you. And if these kind of misrepresentations are made before the court, we can't help it. Right in the same mode. In the morning during at the time of mentioning, it is stated that I think met with an accident. I think they said so. They sought for 4 weeks time.
4 weeks.
What is Dhanush Menon is not you? You're not representing him? Huh? Not respondent. Look at the cause title. It says who is the advocate filed the wakalat? Advocate's name. Yes. 12.
I represent the petitioner in this case. Husband before this court, challenging the interim order passed by the trial court.
What is the amount?
Amount is 25,000 to the respondent number 1 and 2, who is daughter and wife.
25,000 is?
Both the petition respondents.
There must be some, what is that breakup between both of them?
Order was clearly mentioned that.
Come to the order.
I number 2 filed by their petitioners under section so and so under BNSS is partly allowed. with an litigation expenses of rupees 20,000. The petitioners are entitled for sum of rupees 25,000 per month from the day.
What is the income of the petitioner?
Petitioner is doing a writer in the some coffee estate.
Income?
15,000 per month.
1.5.
Yes.
Then why did the court grant 25? Come to the order.
Yes. Stating that he is doing an agriculture business and other business. Same as mentioned in the order, Your Honor.
To show that you are the owner of a coffee estate, what is that is filed before the court?
He sold the said property to for his legal expenses, Your Honor.
No, you accept that who own a coffee estate?
He was the owner.
What is the extent?
3.5 acre.
3.5 acres.
Yes, sir.
By selling that property, how much you got? That's what I think that is how it is adjourned to today.
27,000 he got consideration amount.
For 3 acres of land, you get 27,000.
27 lakhs.
Yes,
sir.
So what is he doing with that money? Why can't he pay maintenance?
I availed a loan for his marriage, and also she filed a complaint against me 498A. My parents although faced the inquiry and also the trial also, and after that we got the acquitted for the litigation expenses and other expenses.
You won't be spending 25 lakhs for the litigation expenses.
And also his old age parents also is suffering from.
Oh, you're along with your old age parents, your wife is also your responsibility. Yes. Wife and your children are your responsibility.
We're ready to deposit, but.
Please come, pay 15,000. It is submitted that though his income is 15,000 per month, the court had granted maintenance of an amount of rupees 25,000 to the wife and the daughter. It is submitted that the court has failed to consider the financial status of the husband. When this court has perused the order, it shows that he is having coffee estate. When this court had specifically asked what is the amount that fetched by selling that property, it is stated before the court that an amount of rupees 25 lakhs. Considering the same, there shall be stay of all further proceedings on the condition that the petitioner shall continue to pay 15,000 by 5th of every succeeding month.
10,000. Maybe 10,000.
15,000 by 5th of every succeeding month, and any arrears at 15,000 shall be paid within a period of 8 weeks. The default order.
13. Jagdish DC.
The petition filed by the husband challenging the impugned order passed by the family court on I number 3.
How much is granted?
Sorry, ma'am.
How much is the maintenance?
Maintenance amount is 20,000 rupees plus 40,000 rupees as litigation expenses. The case is that the petitioner had married one Gunashila. She was best with the son, and unfortunately she died due to cancer. After 17 years of marriage, at the death of his first wife, he has married the respondent, who is also a divorcee. She had married one Shiv Kumar, and some differences arose between them. Shiv Kumar husband filed a petition before the family court seeking for divorce on the ground that the respondent, who is respondent herein, she was a wife of that person who was in the habit of suicidal tendency. She used to pick up quarrel, and in the midnight she used to raise voice and disturbing the neighbors and also the her husband. And ultimately he filed a petition for divorce. Divorce petition came to be rejected. That was challenged before this court by him in MFA. In the MFA matter, that petition was appeal was allowed, granting decree of divorce on 13B, because both agreed for mutual. She received alimony. Afterwards, after 17 years of the divorce, she has married this petitioner who lost his wife. She died because of cancer.
So
And
all this you're narrating is about the wife's litigation.
to show that.
No. For the understanding of the court, I'm asking. Now,
Yes.
what all you have narrated about a case dismissed by the court, that's with regard to wife.
Yes, ma'am.
Hmm.
Here,
Then she married.
she is
this
also
petitioner.
working in the company. She is drawing 1 lakh. I'm told that 1,50,000 rupees. And person is also working in a micro lab company. He is also drawing rupees 1,35,000. And he's being fed up with the after marriage of this respondent by the petitioner. But she did not like the son born to first wife to stay with him. She picked up quarrel. She used to pick up quarrel, and same conduct was there with the petitioner, who is the both are have married second wife. Petitioner says the marriage is
So
also
that I
second.
understood.
Yes.
Yes.
And but ultimately, she has given complaint also before the police.
Those are
She
all
used to
not
shout,
relevant for
ultimately,
consideration of this interim
ultimately,
application.
having no other alternative, petitioner filed petition
Yes.
before the family seeking for
Yes.
divorce. During pendency, the respondent filed an IA number 3 seeking for maintenance. The family court has ordered for maintenance amount of rupees 20,000 per month and also litigation expenses. Here, she is having a own house. She is getting rent from the
Your
one floor.
salary is?
Salary is 1,50,000 according to me. In fact, I made an application to the family court. She has not given actual salary which she is drawing. She has already put in 30 years of service. She is a team leader. She is getting more than as per instruction.
As per the order, how much she's getting?
As per the order, she did not give correct picture because
No, that we have,
therefore,
as of now, unless and until you place something on evidence, we have to go by the order of the court.
petitioner filed an application seeking for
Please come to that.
seeking for salary certificate from the employer of the respondent.
Come to paragraph number 11.
Yes. The petitioner is drawing salary of rupees 1,30,000 per month, out of which he has to pay EMI of rupees 74,000 for his home loan, and his remaining salary is not enough for him to meet out other expenses like insurance, food, petrol, and other miscellaneous expenses of the petitioner. He is not drawing rupees 3 lakhs as claimed by the respondent. The respondent need not take care of her parents, and both parents of the respondent are no more. The respondent is single lady having no issues. She is earning more than her requirement for her maintenance and trade for rejection of the application. She has stated that she is drawing salary of rupees 30,000 per month. She has not given correct picture of her salary. Therefore, petitioner filed an application seeking to secure the salary certificate from her employer. That application came to be rejected. And now this order is passed by the family court on the ground that as per the living standard of the petitioner.
So, as per the evidence on record as of now,
Yes.
her salary is 29,273.
That is wrong. That is wrong.
What to
Yes,
say?
as per record, that's
Yes, and your salary is 1,30,000. Court had granted 20,000, and this court finds no reason to interfere.
Not here. Petitioner is not liable to pay
If
any
you
maintenance.
say so,
Because
there should be some document on record.
Yes, I have produced photographs of the house where she is residing. She is residing in one floor, and she has let out one floor to the tenant.
Notice to the respondent.
Till such time,
No.
here. If
We
she
can't
makes an
grant
application for
stay.
enforcement of the
There should be
all
a
false on
substance.
number
No,
three.
you should make out a case for stay. Stay is
Certainly, we have
not
got a case.
a matter of course.
Certainly, we have got a case, but to grant for interim order. Reason is this matter. Both are both parties' marriage is second marriage. After she has willfully intentionally disclosed wrong age, she has given 2 years less. In fact, her date of birth is 1967. She is of 57 years of old, and petitioner is 2 years, younger to her. And you ask me, can you see what was her character with her first
All those
husband?
things will not consider, Mr.
I have got certificate copy of the certificate copy
We'll
fact,
see, let notice court.
we
to
have
her,
to
let her
see the
come.
petition filed by her first husband. What is the
What
allegation
can be
made?
the order is, if you are ready to pay the amount, we'll grant you for that, to pay that arrears of 20,000, a reasonable time of 8 weeks will be given. I'll not stay the order or reduce the amount.
She is not depending on me. She has her own salary. She has her own salary. She's getting the
That's
rent
not
from
the
her
law.
house.
That's
And
not the
rent-free
law on
house she's residing because her own house. Besides, she's having a site and she has no issues. She's alone. She's working more than, I'm told that 30 years of experience she has got. She's a team leader. And she has troubled.
How do you expect the court to infer all this? I can't take your oral assertion.
I have produced document.
What is the document?
Can you see the photographs? Can you see
Was it brought before the court? Was it there in the evidence? It was not there. That's not the finding of
Evidence
the
is yet
court.
to be started. Now the case is a stage of evidence.
No. Now, only order that can be passed in this is to pay the maintenance at 20,000. If you want time, we'll grant 8 weeks time. On that only, proceedings will be stayed.
Or
Nothing else.
May I make one suggestion?
Yes.
Let there be a direction to the payment to dispose of this case itself within a period of 3 months. Till such time, let them not enforce the order. So
No.
otherwise, she will go on taking time. She will make an application
Sorry, Mr. Counsel, that's not the scope of the petition. Notice to the respondent.
till such time, let there be an order of interim, at least 50%, at least.
No.
20,000 is ordered, 10,000 will go on depositing.
No.
In fact, she is not depending on me. She is not me.
Counsel,
She has her
please
own income,
understand.
own
I'm not-
property.
Court is not convinced with that. Why do you want to again repeat it? I'm not convinced
This
on
is the
that.
real fact, no? It's a
I'm
real
not
fact.
convinced on that. I told you that this is the order. If you want, I'll pass the order or else
Then
notice.
notice returnable by some date may be given so that.
Yes,
she
notice
will
to the
appear in
respondents, list this matter on 2nd of July.
See.
Next.
14 adjourned. 15 Siddhartha Padmanabh.
Yes.
The respondent is the wife. I
Yes.
represent the husband. Matter arises out of this JNWC. An application was filed seeking visitation rights.
Yes. What's the order?
No, but actually what has happened is the petitioner lives in America. So he has now,
Petitioner is the father.
he has now come down. Originally, my lord, the family court permitted us to have a visitation right by visiting 2 sons. That order, lordships will get it at page 171.
Yes.
174 is the relevant portion.
Yes. Yes.
174. It actually starts from 173, the last paragraph. The petitioner is granted visitation rights. He can go to the house of respondent, see his children for 1 hour on every Sunday from 10 a.m. to 11 a.m. with prior intimation to the respondent. He is entitled to take the children to nearby park during that period and safely return to the custody of the respondent, but which order was complied with. Now, my lords, in the final order, the family court does not permit this visitation right, but only says by WhatsApp or an audio or a video.
What are the
call.
reasons recorded for that?
Please. Page 34 is the relevant portion.
Yes.
At page 36, my lord, father is irresponsible. A very stray argument has been
Let's
advanced.
read from-
No finding is
Let's
recorded.
read from paragraph number 4.
Please. The petitioner in his petition has specifically contended, since in inception of their marriage, this respondent was adamant and used to ill-treat both him and his family members. The respondent in his objection statement has contended the petitioner and his parents ill-treated her and her parents. The petitioner has contended that after some days of their misunderstanding and differences, on 12/6/2022, the respondent picked up quarrel with him and then police case in USA has been registered. The petitioner has contended after the incident of police case, the respondent came back to Bangalore with their 2 children. The petitioner has contended on 22/1/2023, he came back to Bangalore for seeing his children, but the respondent and their family members did not allow him to access his children. The respondent in her objection has contended that the petitioner came to Bangalore on 22/1/2023.
What is the IA that you sought?
IA is for visitation. And
What is interim custody?
interim custody also. Now, my lords, the we are now not only restricting our claim to this.
So far restoration is concerned,
Only Saturday, Sunday, my lord, he is
it's for
here
the
now.
welfare and in the interest of the children, that the petitioner father shall allow to communicate with both his children.
Audio, but page 37, only audio video is given,
It's coming up for the first time.
first time.
Take out hand summons on the
Please,
council.
we'll do that.
appearing-
my lord. Lordships may also permit us to take out notice on the council who appeared.
That's what I'm saying. Land council for the petition is permitted to take out hand summons
Lords
on the
could
council.
have any date next week, but the reason
appearing
is,
for the- Appearing for the respondent before the trial court and shall file a memo to that effect. Immediately after the memo is filed, list the matter.
please.
For admission, serial number 16, G. Sukumaran.
Petition in this case, my lord, senior is in quota number 7. Kindly pass over the case, my lord.
Let's see what is, let's see the order sheet. What's happening? Yes, to post this matter tomorrow. The 17th. Tomorrow.
Serial number 17.
And no adjournments tomorrow. No passovers. No passover. Yes.
Serial number 17, Nanjundu Swami N.
This is matter. You have a stay?
ಇದರಲ್ಲಿ ಸ್ಟೇ ಏನಿಲ್ಲ there is no stay, my lord, because this petition filed by the minor son earlier at that time for
Enhancement of
enhancement.
This is matter on 3rd of July at the request of land council for the respondent. Yes, 18.
18, Mamata Shetty.
For council on record, my lords. She's not keeping well. Maybe taken up on next week, my lords.
List it on 9th of July at the request of land council for the petitioner. Next 20.
19, Arjun 20.
Shorter date. I'll list this matter on 25th. Yes. Yes.
20.
Lord, petition, right? 20 IPV. No, last occasion, Lord, your lordship has directed me to produce a document whether the amount which has been paid or not. Lord, entire amount which has been ordered earlier, whatever the dues, my lord, to the respondent which has already been paid before the trial court.
Give him a copy of it.
I'll give you. Told.
Land council for the petitioner submits that, for the husband submits that. He has paid all the amounts and all the dues are paid.
Sure.
And in that regard, he had produced the document to show. And the same is served on the council appearing for the respondent, and the land council appearing for the wife submits that. He'll get instructions in this regard. This is matter on 26th of June.
Lord, that is also maybe record because that 2 months, because next date, my lord, where the matter is pending before the trial court, that amount also will be paid. That is what we can undertake.
Yes.
Remaining amount, 2 months which has to be paid, that will
And
be
he
paid.
submits, and only 2 months amount is left. That will be paid by,
Our next date of hearing is before the
by the
trial
next date of hearing before the trial. Yes.
court. Date is given.
What is it? That's what I said date. 26.
26/6 of placement.
Yes,
But
sir.
any, it may be called in first week of any July.
I'll list it on 8th of July.
First placement.
Yes.
Number
But these
21.
two documents, some place.
You can file in the register
Oh,
time.
please.
Or else take it because it's already
It's all
recorded.
certificate copy.
Yes. Yes, 21.
21.
I'm for the
Yes.
Petitioner has filed a divorce petition after respondent, petitioner came to know about her adulterous life and filed 498A and filed 125 for maintenance. She was working before separation. Subsequently, with the intention, she has resigned. We are not, we don't know about her resignation. Subsequently, we filed an application seeking salary from the
Moved
company.
the memo. You moved the
I
memo.
have moved the memo, my lords.
please.
What is the urgency for you?
My lords, the proceedings before the
State.
below has been stayed. And ultimately, they are
why
not
should be
prosecuting
stayed?
the matter.
By the court, but proceedings before the trial court be stayed in
No,
this
because
matter?
regarding interim maintenance, I summoned from the salary certificate from the employer. We came to know that she has resigned. And subsequently, she has joined CSM.
Or let's take that all those facts into consideration. Still, why the proceedings of the trial court? Shall be
Otherwise,
stayed?
if it is proceeded, interim maintenance will be aborted. She was.
That will be decided by this court. And if this court feels that it has to be again reheard, then we will set aside this order and send it. For that, why the MC shall be stayed?
No, actually, we summoned from the PF commissioner regarding.
It come. The petition is pending here. If the court feels that what you say is correct, then we will, because the petition is pending, we will set aside this order.
There are two matters, my lords.
Sir,
One is
correct.
for
If
divorce.
set aside, well and furnished. If you
Not
summon.
now, after hearing.
Correct, my
But
lord.
we can't
If
stay
you proceed
over.
with the matter regarding interim maintenance, will be suffer because I'm ready to take care of the child. There is no dispute about it. I'm
What
ready.
what is the matter?
My
JNWC or MC?
There are
MC
two
both.
matters, my lord. One is MC, which has filed for
What is
13
stayed now?
There is a connected matter which is going on together. That they're taking adjournments on one or the other date that the matter is stayed. Now, I am unable to proceed the matter for divorce also. I filed an entry under criminal miscellaneous 125. He had filed an application under order 91/311 of CRPC for summoning the manager. He was summoned on the last occasion. And he said that the wife is not working. And he has produced his evidence. Now they have filed a similar application. My lords may kindly come to. It's a matter of.
So please give the order sheet.
It was filed regarding that summoning of the salary, but they produced.
Summoning of the salary, suit
Certificate.
proceedings
It was
shall not be stayed. It cannot be stayed.
And moreover, they are not at all appearing before the court. We are not prolonging, my lord. They are not at all appearing before the court for MC matter and 498 also. Just prolonging the matter, just to make them to
It
suffer.
is criminal miscellaneous.
Please, my lords.
What are two proceedings?
Two criminal miscellaneous is filed for interim maintenance under 125 sub clause 1. And under that, along with that, there is also one MC which has been filed. They both are taken together for the court below. And in view of the stay, they are telling let the matters be, let this dispose.
What is the other matter?
It is for divorce, my lords. I filed under 13(1) for dissolution.
In the objection also,
It
we have
is
filed
made
counterclaim for
on-
divorce, my
one
lord.
minute. On 14/2/2025, there's an order granting stay of all further proceedings in criminal miscellaneous number 172 of 2023. It is submitted with the learned counsel for the respondent that in view of the stay granted in criminal miscellaneous number, the court is not proceeding with the MC proceedings also. It is made clear that as far as the MC proceedings are concerned, there is no stay granted by this court and the court can proceed with the same. Yes.
Regarding, my lord,
is a short
interim
question.
application, they are pressing for interim application, my lord.
What interim application?
Maintenance.
Hmm.
I'm ready to pay maintenance to child. I'm not disputing the maintenance, but since she is working and she's living in.
You have whatever is the order pertaining to that, it is state.
Okay.
The other order cannot be
Proceed,
stayed.
regarding
Yes.
proceeding,
Yes.
pertaining to that,
This is matter on 10th of July.
concerning to that order passed in respect of the IA is stay.
Only criminal miscellaneous is state.
Oh, that's
MC
all, criminal miscellaneous only.
That
I
is
thought-
state, that is state.
But regarding MC, I have not taken any stay, my lord.
That I'm
That's
clear,
what
that's
the
why I'm
order is
I'm clarifying it. Yes.
Please, ma'am.
MC, there is no, we have not produced any document for the trial. They are not at all appearing for evidence, my lord.
Yes. Next.
Date might be fixed, my lords. Date.
What date?
A
This
date might be
matter.
fixed. Please, my lord.
You just give the date. What is that? 8th?
Obliged, deeply obliged.
22, SB Halli.
Date.
There are two matters, Malad, in this matter.
Where is the respondent?
ಇದರಲ್ಲಿ 251 RPFC 251 of 2023 filed by the wife and daughter Malad.
Where is the counsel for the respondent?
ಈಗ ಇದರಲ್ಲಿ may make one submission Malad. On 29/10/2024, I have filed the memo along with the order sheet before the trial court. The matter has been settled between the parties Malad. So both the petition become in practice. So filed the memo Malad. On 29/10/24 Malad. The daughter has filed the suit for partition Malad.
1 minute. Your petitioner in which matter?
251 Malad.
251. Learned counsel for the petitioner in RPFC number 251 of 2023 is present. No representation for the Council in 22.1, that is RPFC number 132 of 2023. List RPFC number 132 of 2023 for dismissal tomorrow. In his presence, we'll pass this order
Please.
tomorrow. Yes, next. Huh? Both the matters.
Please.
List 2, serial number 1.
For the petitioner, Your Lordship.
What are the complaints of office objections on IA number 1 of 25?
Your Lordship, IA number 1 of 25 is a stay application that we had filed, Your Lordship.
You had served a copy on them?
Yes, Your Lordship, copies were served and interim stay was also granted. It was a conditional stay that was granted, subject to payment of 25,000 rupees per month to the respondent number 1 and respondent number 2. Your Lordship, we've complied with the conditions of the of this Honorable High Court, and we further we've also paid 25,000 per month to respondent number 1 and 2 until last month, Your Lordship. 17th of May we've paid. We'll undertake to pay for this month as well.
What do you say?
My instructions are that, my lords, the payments are irregular. I'm not sure if they have received the entire amount. Even previously,
According to the Land Council, it is submission of the Land Council to the petitioner that, except for the month of June, they have completed all the, they have paid all the amounts as per the order of the court. Land Council for the respondent submits that, as far as these instructions are concerned, they were irregular in paying the amounts, and he would come up with specific instructions with regard to the payments that are made. This is matter when?
Next week, my lords.
Next week, so give some date. List on 26.
26.
Yes, next.
Please.
Serial number 2, Monisha NS.
Lordships, we have not been served a petition copy in this matter.
What is this?
We have not been served a
The
petition
230.
copy.
230, no. On the next list. No, you called as Monisha, no? Big four, no? I'm looking at this. No. Kamath and Kamath. What papers are not served?
No.
My lord, kindly pass on. Senior is held up in.
The counsel for the petitioners to serve the copy of the petition on the counsel appearing for the respondent. This is matter on 30th of June.
Serial number 3, Shivkumar V.
This case I'm for the petitioners, my lordship.
Telling them not to list the specially mentioned cases where only MC is state, not criminal misdemeanors. In spite of that, they're listing it. Tell them only when MC is state, that should be listed. Yes.
My lordship, in this matter, there is a likely to be settlement. I have instructed to.
Kindly
Matter may be
refer to
referred to
mediation,
mediation.
my
So
lord.
there is a likelihood of settlement, less this matter after 2 weeks.
Kindly fix the date, my lord. Refer to mediation.
Refer the
2
matter
weeks
for
you want-
mediations.
Huh? You want to go before the mediation?
Please.
Which mediation center?
Bangalore Mediation Center.
Submits that there is a likelihood of settlement. As such, the party shall appear before the Bangalore Mediation Center on 26?
Please.
On 26 June.
Please.
Yes, done?
3 p.m. 3 p.m.
No, it shall be in 2:30, yes, that's in the chamber only. As a board, but why it is at 3 p.m. is mentioned, it's 2:30. Anyway, these matters, no.
24 and 25 are in chambers.
No.
23.
1 minute. This matter, I think it should be informed in to come by 2 p.m. In 24 matter, because it will take some time. Ask them to come by 2 o'clock, not 2:30. Inform the council. Is any signatures? 20? No. Where is there? Where is 2 PM mentioned? There's something wrong with your list and my list. It's not the same. No, something is wrong with that. It's over. No, this case is called. You didn't call this case. Show me the case. What is that case? Mother shall immediately hand over the child to the custody of the father. Oh, this matter, 2 o'clock. Yes, all the 3 matters in the chamber from 2 o'clock. And this is the one I'm saying that it should be at 2 o'clock. Ask him to come. They can as well carry this here, no?
ಯಾವುದು ಮೇಡಮ್? ಇದನ್ನು ಇನ್ ಚೇಂಬರ್ಸ್ ತಗೊಂಡ್ರೆ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ಇದು ಲಿಸ್ಟ್ ಯಾವಾಗ ಅಜ್ಜನ್ ಆಗಿದೆ ಮೇಡಮ್ ಅದು? ರೆಫರ್ ಟು ದ ಲೋಕ್ ಅದಾಲತ್. ಥರ್ಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಲೋಕ್ ಅದಾಲತ್ಗೆ ರೆಫರ್ ಆಗಿದೆ.
ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರೆ ತಗೊಳ್ತಾರ ಮೇಡಮ್? 2:30ಗೆ ನಾಳೆ ಬಂದ್ರೆ ನಾಳೆಗೆ ಅಂತ ಏನೋ ಎಮರ್ಜೆನ್ಸಿ ಅಂತ ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತಾರ ಮೆಮೊ?
ಇಲ್ಲ, ನಾಳೆನೆ. ಇನ್ನು ಸಿಟ್ಟಿಂಗ್ ಬರಲ್ಲ ಮೇಡಮ್.
ಇವತ್ತು ಸಿಟ್ಟಿಂಗ್ ಬರಲ್ಲ
ಅಷ್ಟೇ. ಚೇಂಬರ್ಸ್ 2-3 ಮ್ಯಾಟರ್ ಇದೆ ಅಷ್ಟೇ.
ಪೇಮೆಂಟ್ ತಗೊಳ್ತಿದ್ರಾ?
ಇಲ್ಲ, ಹೋಗ್ಲಿ.
ಮೇಡಮ್ ಅವರೇ, ಥರ್ಡ್ ಲಿಸ್ಟ್
ಈಗೇನ್ ಗೊತ್ತಾ, ಅದು ಸೇರ್ಸ್ಕೋಬೇಕು ನೋಡಿ, ಇಲ್ಲಿದೆ ಎಲ್ಲ ಸೇರ್ಸ್ಕೊಳ್ಳಿ. ಅದು ಇದು ಚೇಂಬರ್ ಇಟ್ಕೊಳ್ಬೇಕು. ಇದು ಮೇಘಂಗೆ, ಇದೆಲ್ಲ ಮೇಘಂಗೆ. ಇದು ಇದರಲ್ಲಿ ಒಂದು ಡೇಟ್ ಇದೆ, ಹೇಳ್ಬಿಡ್ತೀನಿ ಯಾವ್ದಂತ. RPC 251 ಇದೊಂದು ಡೇಟು ಹೇಳ್ಬಿಟ್ಟು ಕೊಡಿ ಮೇಡಮ್. ಡಿಸ್ಮಿಸಲ್, ಇದನ್ನ ಡಿಸ್ಮಿಸಲ್ಗೆ ಇದನ್ನಿಗೆ ಸಪ್ರೇಟ್ ಹೆಂಗ ಹಾಕಕ್ಕಾಗುತ್ತೆ ಮೇಡಮ್? ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ ಹಾಕ್ಬೇಕಷ್ಟೇ ಅವರು. RPFC 132ನ ಪೋಸ್ಟ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಅಂದ್ರು, ಸೀರಿಯಲ್ ನಂಬರ್ 22 ಡಿಸ್ಮಿಸ್